Open the roll.
Mr. Chair, you have a quorum?
Okay, thank you very much. What we're going to do, the first bills on the agenda are bills that went through Agriculture, Conservation, and Natural Resources. They're conveyance of easement bills. They're not controversial. We can either report the bills or send them to Agriculture to make sure. They're 1662, 1663, 1828, and 2285. What's your pleasure with those?
Move as a block to report and re-refer to Ag. I think we ought to just take care of them now so we don't have to send them anywhere. I think they're not controversial.
Well, they aren't controversial. The question is whether we know for certain that they are exact replicas of the bills we've already passed.
Is anybody here on this?
Well, we've got a motion to report and re-refer. Just re-refer.
All right.
A motion to re-refer. Open the roll, please. Okay, those bills are re-referred to Agriculture. The next
Senator
bill.
Peake for Senator Stewart.
How many votes are there?
Ayes 9, no zero.
All right.
Okay, the next one is 2054. That it also should be an easy bill, but it's identical to one that went through rehab, and before it was Senator Favola's bill 1267, and so I'd take a motion to re-refer it to rehab. Okay, please open the roll.
Ayes 9, no zero.
Okay, the next series of bills are not, they're on number 3 on your list. They are bills that went through, they had Senate cognates and they went through uncontested without any no votes. The first one is Bill 1425 from Delegate Coiner that's identical to Senator Servel's 801 that reported from this committee 15-0 and Senate 40-0.
Mr. Chairman, I talked to Delegate Coiner, told her she needed to come. I'd move to report that bill.
And I second that, Mr.
Okay, are there other motions? Please open the roll. A yes vote is a vote to report.
Ayes 9, no zero.
Okay, the next bill is 1590 from Delegate Sullivan. It's identical to Senate Bill 1034 from Senator McPike. They were reported from this committee 15-0 and the Senate 39-0. It's one that modernizes the harassing phone call statute to include any communications that may ring or otherwise signal or alert. Do you remember this bill?
Yes, Mr. Chairman, I move the bill be reported.
Second.
Okay, are there other motions? Please open the roll. Green vote is vote to report.
Senator Peake for Ayes 9, no zero.
Okay, the next bill is House Bill 1838 from Delegate Taylor. It's identical to Senate Bill 1241 from Senator Obenshain that reported from this committee 15-0 from the Senate 39-0. It requires the registry to include hash values or other applicable. You all remember this bill, right?
Second.
Any other motions? Please open the roll. A green vote is a vote to report.
Ayes 10, no zero.
Okay, the next bill is HB 1972 from Delegate Leftwich. It's identical to a bill from Senator Peterson, 812. They reported from this committee 15-0 and from the Senate 40-0. It's a bill that exempts from creditor process or repeals a provision that exempted from creditor process emergency relief payments. I think you remember this bill.
Move to report.
Okay, is there a second? Second. Are there other motions? Please open the roll. Vote yea is a vote to report.
Senator Peake. Ayes 10, no zero.
Okay, the next bill is House Bill 2020 from Delegate Waxman. It's identical to a bill that Senator Hackworth had, Senate Bill 1073. They reported from this committee 15-0, from the Senate 39-0. It prohibits any unmanned aircraft system from coming within 400 feet of the lateral boundaries of any local or state correctional facility. You probably remember this bill too.
Second.
Okay, are there other motions? Please open the roll. A green vote is a vote to report. Okay, the next block of bills.
Ayes 11, no zero.
Okay. The next block of bills include House bills with identical Senate companions that were contested. And the first one that's here is Delegate Runyon. Now, he's not here today, so if he gets in any trouble, we're going to uphold this bill. But this is 1943. It's identical to a bill that Senator Peake had, 989, that reported from this committee 14 to 1, and passed the Senate 30 to 10. It requires an attorney for the Commonwealth to consult with a victim in a plea agreement. You might recall this one. I think we just dealt with it last week.
Mr. Chairman.
Senator Servell first.
Yeah, we actually voted it yesterday on the floor, and I think the concern was it might allow a court to sort of meddle in the nature of a plea agreement and how much consultation was done with the victim. And I think that was what the concern was on our side.
Mr. Chair,
Senator Peake.
to address the, Senator Sorrell, isn't this exactly the same thing that your bill with the Attorney General does?
No,
Didn't your bill require the Attorney General to notify the victim?
Mr. Chairman.
Senator Servell.
My bill just requires the Attorney General to do whatever a Commonwealth attorney would be required to do, which under current law doesn't require a conversation prior. It requires a communication at some point in the process. Your bill requires, I think, a little bit more specific type communication.
Do you want to wait for Delegate Runyon to be able to be here
Yeah.
to discuss this bill?
Yeah, let's do that.
Senate. The Senate cognate was from Senator Peake. It was one that passed this committee 14 to 1 with one abstention, passed the Senate 30 to 10. It was Senate Bill 989.
Mr. Chair, just to answer Senator Peake's question, Senator Servell's bill just required, as he said, the AG to do what the CAs would do, whereas the Senator Peake Delegate Runyon bill eliminates the victim's written request to be notified. So it mandates that the CA notify or consult with all victims.
Mr. Chair,
Senator Edwards.
does this, it requires notification, but does not require agreement. Is that right?
Mr. Chair, that is correct.
Well, what's your pleasure? Do you want to wait for Delegate Runyon to be here?
Yeah, let's do that.
Okay, well, this bill will go by for the day then. Senator Jenkins has 1836 that passed 80 to 18. It's identical to a bill from Senator Eben, 1089. They reported from this committee 9 to 6 and passed the Senate 2216. Senator Jenkins here. Delegate Jenkins.
Mr. Chair, Committee, Elizabeth Pollen, Virginia Housing Commission. Senator Delegate Jenkins is not here, but he does have a line amendment that he wishes to add.
Do you have the amendment?
Do not have the line amendment. They're looking for him right now.
Okay. Well, with this one, we'll go by temporarily. The next bill are House bills with Senate companions. House Bill 1416 from Delegate Brewer, which is similar to 1436 from Senator Donovan. We reported and re-referred that bill to Finance 15 to nothing. It reported from Finance 16 to nothing. Passed the Senate 39 to nothing.
Mr. Chair,
Senator McClellan.
I move that we conform House Bill 1416 to Senate Bill 1436.
Okay, all in favor of that amendment, please say aye.
Aye.
Opposed? Okay, it's not on the list to go to Finance.
Mr. Chairman. Servell.
And I heard you, Servell. I'm just trying to make sure I didn't mess something up. But there was okay. I didn't, no, it wasn't related to this bill.
Mr. Chair.
Senator Servell and Senator McClellan.
I just wanted to confirm that this was the bill that went to the Crim Subcommittee. I think it was like the only bill we heard.
Mr. Chair, that is correct.
Mr. Chair,
Senator McClellan.
since the now identical bill was reported and referred to Finance, I so move.
Second.
Okay, any other motions? Please open the roll. A vote yea is a vote to report and refer. Okay, thank you, Delegate. Wonderful presentation.
Ayes 12, no zero.
Have one more bill?
You have another bill? Let's see.
House Bill 1687.
1687, that's a bill that I do have a finance note on. It has to go to finance, and that's over on page 7 of your agenda.
1687.
1687. If you want to give your attention to Delegate Brewer.
Thank you, Mr. Chair. House Bill 1687 is actually an expansion to the Sex Offender Supplemental Registry. As you all know, since I think almost everyone's an attorney, the Sex Offender Registry was created July 1 of 1994, and any crimes committed prior would have been on the supplement that only goes back to 1980. Unfortunately, this is, I feel, necessary for our communities because since parole has happened, we have had several people that have gotten out into the community that are not showing up in the supplement. A story just from my hometown in Suffolk, there was a 78-year-old woman that was abducted, raped, robbed, and then murdered in her home. And her killer was let out after he was given 3 life sentences just 2 years ago. And so I think it's the public's right to know if if these people are allowed out, that we should certainly be able to know where they're residing. So
Delegate Brewer, if I can understand, that you would propose any conviction that occurred on or after July 1 of 1970 would trigger inclusion?
anyone who was let out on parole, if their crimes are committed after 1970 going forward, just to expand the registry back to 1970, currently arrested in 1980. This
Okay.
crime was committed in 79, so therefore it would encompass that.
Okay, so, but theoretically, anybody that say they were convicted of something in 1970 and they were released on parole in 1974, they would have to register?
Well, they don't have to register. They will be added to the supplement via state police.
I'm trying to find out, Mr. Chairman, where is the change? Oh, I see, you changed 1980 to 1970.
It's down on,
Line
take a look at.
15.
Yeah, line 25.
And to speak to line 25, just so you're aware, the reason that has that date between 70 and 75 is because there was a realignment of the code section, and that's why there's an odd date in there of 1975.
So what is it? Mr.
Senator
Chairman,
Edwards.
On line 25, what's the change? Maybe my eyes are not very good, but is there a change on line 25?
So,
New
Mr.
language on 25.
Right, Mr. Chair, the amendments on lines 24 down to line 35 deal with the recodification of Title 18.1 that was done in 1975. So this is just trying to make sure that those code sections that existed in between 1970 and 1975 are included in the supplement.
Mr. Chairman,
Senator
it
Edwards.
doesn't look like it's anything new. Am I missing something, or
That's new language, John. It's italicized language.
I don't see it italicized.
You're not looking at the right bill, I don't think.
1687, Brewer. I don't see any italicization. What am I missing?
You have a different bill from the one I've got. He has a
This
different,
is that's the introduced version, not the.
there's a House substitute in there should be.
Do you need my copy, Mr. Chair?
But you can see my copy right here.
Maybe I don't have it. Okay,
I've got it right here.
okay, all right.
Mr. Chair, I'm going to give Senator Edwards my copy.
Oh, I see.
And these effectively are the codes of 1975, so the application of 75.
Page 7.
Page 7.
Page 7.
It's House Bill 1687.
Mr. Chairman,
Senator Morsi and then Senator Ogleshane.
This whole page was they were referred to.
Thank you. In any way, does this bill expand this registry, add crimes to it other than existing crime, other than the same crime, but people that committed it in an earlier decade?
Mr. Chair, to answer the question, I would tend to say no. And I say that because I'm unsure, since it is different crimes, how the elements match up specifically. But what I would say is the crimes are very similar, does not add anything new that would require people to register who would not otherwise be required to register, provided that these crimes existed between 1970 and 1980.
Mr. Chair,
Senator Morrissey.
you may have broached the subject in an earlier matter, but one of the things I'm concerned about is the SOR is an ever-expanding registry that when people first went on it, were going to be on it for 10 years, extended to 20, 25, and then life, and they can't get off of it. That's my concern about this bill. Are we in any way expanding it to the degree that I just said?
I think the way I look at this bill, the only thing you're expanding is that you're expanding the auxiliary list to people that were convicted of offenses at an earlier date.
That would have been on it had it existed then?
Had it existed, then it would have been on.
Mr. Chair, I can answer maybe a question that Senator Morrissey had. According to VSP, this would affect approximately 1,890 individuals possibly.
Okay, Senator Obenchain had something, I think.
Yeah, Mr. Chairman, I mean, my understanding is that this doesn't impose any new obligations on those people. They don't have
Correct.
to do anything. They don't face any liability for failing to do anything. This
Correct.
is all state police and administrative.
This is all administrative that they estimate that they could absorb, and also there is no requirement on behalf of the person to interact.
Thank you very much.
Chairman,
Okay, Senator Surville.
that's maybe, Councilor, maybe Delegate Brewer can clarify for me, but I assume not all of these were trials. Some of them were probably pleas. A lot of them were probably pleas. But is it fair to say that at the time, everybody who this would add to the list entered their plea agreement, they had no idea there was such a thing as a sex offender registry, and they were going to be put on some list that makes them radioactive the rest of their life? Yeah.
Mr. Chair, Senator Surville, so very specifically, I do have from DPB the older code sections of what that would include, if that would make you more comfortable, if you'd like to see those.
Mr. Chairman.
Senator Surville.
And Delegate Brewer, not that the crimes or whatever doesn't make, what worries me is that there's a bunch of people who entered into plea agreements that had a certain set of consequences in mind at the moment they entered their plea agreement. And had they known there was going to be some list that put them out in public, that every time they moved, every neighbor around them head would explode, they might have entered a plea agreement. They might have actually chose to go to trial or plead to a different charge. There's a whole element of due process in this that bothers me, and especially coming in, what is this now, 40 years later, and adding consequences to something that happened 50 years later and adding consequences? That's a really significant step by the government from my perspective.
Mr. Chair. To Senator Surville, what I would say is my intention is to catch the ones that probably had several life sentences that are now out walking our streets. And I think it's the public's right to know that, especially in instances that are pretty egregious, especially for those that have been let out free, that have raped, abducted, robbed, and murdered someone, that the public has a right to know. But what I would say is if you're concerned about the length or the scope of the crimes, I'd be open to a friendly amendment if it would make you more comfortable.
Is there an amendment that would make you more comfortable, Senator Surville?
No.
Okay, Senator Morrissey's got something.
Yeah, Madam Chair, Mr. Chair.
Senator Morrissey's got something, then I'll come to you, Senator.
Delegate Brewer, do you consider the requirement that this person be added to the SOR, to that individual from the 70s or early 80s, to be an additional punishment, even a modicum of punishment?
Mr. Chair, Senator Morrissey, what I would say is I don't find this to be an additional punishment. What I believe this to be is the public's right to know. I've spoken with this victim's family and other victims' families that they just feel like that they have a right to know that that person is back on the streets, because when they were originally sentenced, they had a peace of mind that the person that committed this crime was given 3 life sentences, now walks our streets. And so this puts no additional effort of notification on the perpetrator, but it does give a peace of mind to the victim and their families. Also, there are people that, and especially in this instance, this person is their early 60s. This person could reoffend, and I think the public has the right to know that they should be out of this registry, and that I hate to say ostracize, and I think that's might be what you're wondering, but I think the safety of the public probably is much more of a noble cause and probably the intent of the assailant.
Brief follow-up question, Mr. Chair.
Senator Morrissey.
I'm not worried about ostracize, although concerned. I'm worried about it being an ex post facto law and a violation of the U.S. Constitution. But with that said,
Senator Chairman, Mr. Chairman.
Here's my question. My question is, if the person is there a requirement now that this person register? And if he or she doesn't, does that carry any punishment?
Mr. Chairman, Senator Morrissey, there's no requirement for the person to register. This is only an administrative action from state police.
All right, thank you.
Okay, Senator Edwards.
Yeah, how can you say that the individual convicted between 70 and 80 doesn't have to do something? Something's done to that person though, right?
Mr. Chairman, Senator Edwards, so what I would say, and the reason that I went back instead of when this crime was committed from 79 and going all the way back to 70 is the likelihood of the age of that person, if they're released on parole, is going to be of such a geriatric nature that I think 70 will cover this and we'll never have to come back here again.
Well, yeah, as somebody who's older than that, how can you say though that the person doesn't have to do anything? Do they have to register? They have to register, don't they?
Mr. Chair, Senator Edwards, there is no need on behalf of the person that was convicted to do anything, to register for anything, or to contact anybody. This is simply a administrative action on behalf of state police to expand the registry back to 70 and add those to their existing list.
Mr. Chairman, my concern, I guess similar to some of the others, but something is over their head, so to speak. Something would happen to them if they didn't or did something that would not have happened otherwise.
Mr. Chair, so the subsections where this bill is drawn to, subsection C specifically provides that persons whose name and conviction information appear on the supplement are not subject to the registration requirements of this chapter and are not considered persons for whom registration is required unless they require to register for other reasons. So this doesn't necessarily hang anything over their head other than they are on a supplement that is publicly available, letting essentially the world knowing that they were convicted of these offenses.
Well, Mr. Chairman.
Senator Edwards.
Counsel, answer this question. Why is not the ex post facto law involved?
So, Mr. Chairman, this is consistently has been held that this is not a punishment. So there is no ex post facto considerations. That the registry and the supplement are administratively done to provide protection, and both the U.S. Supreme Court and Virginia Supreme Court have consistently held that this is not an ex post facto issue.
Mr. Chair.
Senator Delegate Brewer.
Senator Edwards, so someone had asked me, in essence, does this apply? Is it a double jeopardy situation? It doesn't. It's not. What he said is absolutely correct. The sex offender registry itself was created in 1994, and that created an additional action. This is only an administrative action, and so therefore, I think it's a different circumstance, sir.
Are there people here that would like to speak in favor of the bill?
Good afternoon. I'm Heather Havermel, Commonwealth Attorney for the City of Winchester, here on behalf of the Virginia Association for Commonwealth Attorneys. We are in favor of the bill. I'm happy to answer any questions you might have of me.
Okay, thank you, ma'am.
Thank you.
Are there others? Are there people who would like to speak against the bill? The bill is before the committee.
Move the report.
Are there other motions? Open the roll of green
Substitute
vote
motion to
as vote.
PBI, Mr. Chairman.
And to finance, report and re-refer to
Mr.
finance.
Chairman, substitute motion to PBI.
Substitute motion to PBI, is there a second? Second. Okay, the substitute motion takes precedence. A green vote is a vote to PBI. Please open the roll.
Yeah.
Ayes 8, no 7.
Ayes 8, no 7, okay.
Thank you, Mr. Chair.
Thank you, ma'am. Back to the order, Delegate Campbell with HB 1541.
Afternoon, Mr. Chairman.
Turn your attention to Delegate Campbell, please.
Mr. Chairman, members of the committee, House Bill 1541, you said earlier.
1541 is similar to a bill that Senator Surville had, the 799, it reported from this committee, 15-0, from the Senate, 40-0. So it's similar. Would you oppose a motion to conform this to Senator Surville's bill? Are you familiar with that?
I think I would be okay. I'm not sure the difference exactly in the two of them, to be honest with you.
I'm not sure the difference either. Charles, do you know what the difference is?
Mr. Chair, the only difference between SB 799, which is Senator Surville's bill, and HB 1541 is that SB 799 requires 30 days written notice versus 10 days, and it also includes a subsection B that has a 15-day deadline for responsive pleadings.
Mr. Chairman.
Senator Surville.
Right. Mine had a longer time period that you had to file this because I had a concern that if these records only dropped on opposing counsel 10 days before trial, it only gave somebody responding like a very limited time to respond, and it might result in a lot of continuances. And I thought 30 days would make it a lot more workable.
What I'd prefer to do is just have one policy come out of this committee, and then if you want to work it out in conference.
That's reasonable to me,
Okay.
Mr. Chairman.
I'll entertain a motion to conform this to 799. Okay. A motion for a substitute. All in favor, say aye.
Aye.
Opposed, no. Okay, is there a motion to report?
So moved.
Okay, motion to report and a second. Are there other motions? Please open the roll. A green vote is vote to report. Thank you, delegate.
Thank you.
Ayes 15, no zero.
Mr. Chair, I have two other bills,
You
I
have two
think,
other
maybe on the
bills.
docket. I'm not sure if they were cognates or
You're
not.
awful lucky.
Yeah.
Taking a chance now.
Oh, yeah.
Okay, they're not cognates, I don't think.
Yeah,
What are the bill numbers?
1756 and 1757, both were recommendations of the Boyd Graves Conference.
Yeah, and they both came out 98 to nothing. The Boyd Graves bills, guys.
Yeah.
Very carefully.
That guy gets more through than anybody I know up here, to be honest.
Okay, 1756, you want to do that first?
Sure, I'd be happy to, Mr. Chair.
Mr. Chair, I mean, anybody
Senator
who looks
Oberste.
at this makes 100% sense, and I would move the report. I mean, if you issue a subpoena, you can release it.
Yeah.
Release a witness.
Okay,
To
is
be
there a
quite
second
frank,
on that
in my
motion?
practice, I have done this for years, and I've followed this practice, even though it's not written in the rules, so I think it makes
Absolutely.
perfectly.
Is there a second on the motion?
I'll second that.
Okay. Are there other motions? Open the roll. A green vote is vote to report.
Mr. Chairman,
Strike the roll. Senator Benjamin.
no, I'm just the lawyer.
No, Senator Benjamin.
Look, my only concern is that this, for many of us, it was a surprise to hear that you can't just release your own witnesses. I do it all the time. And so it's a great bill, but it adds additional requirements, I think on line 75, 76. So the committee might want to consider whether to pass the bill, which is a great idea, but not with the additional requirements of doing it in writing and so on and so forth.
Mr. Chairman, most of us, I know some lawyers who don't send copies of attorney-issued subpoenas to other lawyers, but I think it is required. And I think that this is a prudent and appropriate guardrail to insert in there to make sure that nobody is erroneously relying upon the assumption or belief that a witness will actually be there at trial, and to put them on notice that the subpoena has been released. I just think this is a transparency. It's just like discovery.
Mr. Chair.
No trial by ambush.
Senator Morrissey.
I find myself agreeing with the gentleman from Rockingham, but I would also suggest on line 76, where it says, and served concurrently on all other parties, would it make sense, would it be prudent to also say, including opposing counsel, who may be relying on the attorney-issued subpoena? Would you be in agreement to that?
So,
Senator Morrissey, I think that's a fine amendment, to be honest with you. I think, in addition to that, I will say too, not to muck this up, but I did have an 11th hour amendment from the circuit court clerks who asked if they also be given notice of the release. A lot of us rely sometimes to our detriment on other attorneys' subpoenas. Probably not the best practice in the world, but we do sometimes. And so obviously it's good to know when they've been released.
So serve concurrently on all other parties, opposing counsel, and the clerk.
Mr. Chairman.
Mr. Chair.
Let me just offer a respectful counterpoint to that. The rules specify how you serve an opposing party. And if they have counsel, it is through their counsel. I wouldn't want to create a situation in which I'm now required to send a copy to my opposing party and to counsel. Create some disciplinary issues in addition.
Mr. Chair.
Why don't we change it to all counsel of record and the clerk then?
Mr. Chair.
Senator Peterson and then Mr. Benjamin.
I want to support this bill, but here's the problem. I don't think anyone's mentioned this. What happens if you're going to trial and you need to subpoena witnesses and you confer with your opposing counsel and, oh, are you going to get Mrs. Smith there? Oh, I already got her under subpoena. Are you going to get Mr. Jones? Oh, I got him under subpoena. And you rely on opposing counsel having already subpoenaed that person because nobody's going to subpoena them twice. That, frankly, could be sanctionable if you subpoena them twice. I mean, you get the sheriff out there 2 times. And then on the eve of trial, they release a subpoena. And Mr. Smith doesn't show, and Mrs. Jones doesn't show, and maybe you had forgotten to renew your malpractice insurance that month. I mean, it could be, that's a problem.
Well, I think both counsel are standing in front of the judge explaining, what's taking place there too. And I mean, if
I agree
yeah.
that a good trial judge is going to kind of figure that out, but.
Good lawyers can issue that subpoena.
Yeah, I think there's a reason why in the code we've only had the judge release, I think it's for just that purpose, that once they're subpoenaed, that's a court order for them to be there. And attorney-issued subpoenas is a huge convenience for all of us.
Agree.
But releasing it's a little bit different, because that could jeopardize the other parties.
it's a reason in practice, I've always given notice to the other counsel so
Yeah.
that they would have an opportunity to re-subpoena them if they choose to do so.
I get it, and an honorable counsel and integrity, but I got to do business with people up in Maryland, okay?
And even worse, Fairfax County.
To be blunt.
Senator Edwards has something. I'm sorry, Senator Norman.
I would say, Mr. Chairman, that my malpractice insurance is paid up, and especially in criminal cases, even if the Commonwealth has subpoenaed a witness, I subpoena them because then if they release them, I'm in a world of hurt. Happens all the time.
Mr. Chairman.
Mr. Chairman.
I'm sorry, Mr. Benjamin.
No, I just wanted, it sounds like there might not be a policy objection to limiting these requirements to civil cases. And so you might say, provided that in civil cases, there's these additional requirements. And the reason is because in the criminal context, I can't tell you how often a week the prosecutor will call me the day before, the night before a preliminary hearing and say, I need a continuous, can I release my police officer witnesses? And of course you say yes, and it works both ways. We're doing that all the time. And there's no opportunity to do it in writing or to serve it on people. And so that's for the committee's consideration.
Mr. Chairman, I think that's an excellent suggestion, and I would move it because, besides, I don't think Boyd Graves has any business messing with criminal stuff anyway.
Well, Senator Servell, do you have something on that point? Limiting this.
I had another thought about that point, and I missed part of the discussion, which I apologize for, but then I had a separate idea to try to fix this. But
Okay, well, I think the language would be to limit it to civil. You have, Mr. Benjamin, you've got this.
On line 75, after the word provided, insert that in civil cases.
That in civil cases, such release be in writing and served concurrently on all opposing counsel.
Mr. Chair.
Senator Morrissey.
I would suggest to staff that I understand what Mr. Benjamin said, that there's a colloquy back and forth between he and the Commonwealth's attorney, but if you don't have criminal in there, that other colloquy may not occur, and that prosecutor may not say to that defense attorney, do you mind if I let him go? I do not like carving it out just for civil, for that reason.
Mr. Chairman.
Senator Servell.
Can I go back to what my idea was, which is mean, it seems to me the problem that arises is that if somebody releases a witness that you're relying on being there and it comes late, you could not have time to resubpoena the witness. So if we said that the attorney can release the witness 15 days or more before trial, wouldn't that protect you from not being able to resubpoena that witness to come?
It would, but it's going to make this bill 98% meaningless. Yes.
Mr. Chair, I got
Senator Morrissey.
We started down this road when our staff suggested that maybe we could take additional language out beginning on line 76. As Mr. Kilgore, Delegate Kilgore would say, let's get your own bill. This bill is fine. We're mucking it up. Let's keep it the way it is with the addition, including opposing counsel and clerk, and move it forward.
Senator Obenchain, you have an amendment on the floor. Do you withdraw that amendment, or do you want to? Okay, the amendment's withdrawn, including opposing counsel and the clerk of court. Have we agreed to that amendment?
Mr. Chairman, I think when you say parties, you're really referring to counsel or parties without counsel. That's how I've always started. Parties meaning counsel automatically.
Mr. Chair, also, if I might, with respect to the clerks, it's a bit different. I think the language in the bill requires service to be by electronic mail. The clerks have requested that it be by fax. And my suspicion is that there's a lot of clerks' offices that don't check their email. So, yeah.
Okay, do you have language from the clerks?
So this is evidence that no good deed goes unpunished. So, I have proposed language from the clerks.
Don't put that in there. Okay. Senator Servell and Senator Obenchain.
I don't know.
Senator Deeds, does Bath County still use the fax primarily?
Some of them do, I guess.
I'm going to put it off a week. Mr. Chairman, I suggest we put it off for a week to get some of these kinks ironed out.
If we put it off until Monday, if you can have the language worked out? Okay. Put that back for the day without objection. 1757, it's another 98-0 bill. I assume we're going to have to spend another 20 minutes talking about it.
I'm afraid that may be the case. I was anticipating actually this to be the most litigated one.
Mr. Chair.
Senator Peterson.
Is this a slap suit? 8.01 dash whatever it is?
It is.
I would ask this go to civil laws sub, and the reason is I have a bill on this, and what I'd like to do, Delegate, is perhaps we could even marry our two bills up. Since you're from Marion, Virginia, you can appreciate that. I'm here all week, folks.
So respectfully, I'll accept Senator Peterson's proposal.
He chairs the civil law subcommittee.
We'll take care of you.
That's fine. Thank you.
Thank you. The next one I've got is from Delegate Webert, 1859. Is he here?
I talked to him. His was identical, I believe.
It is similar to, okay, do I have a motion to conform to Senate Bill 1183 from Senator Reeves? Do I have a motion? Okay, all in favor of it's a wrap back. Going back to Senate, do I have a motion? I had a motion to conform with a second. All in favor of conforming, say aye. Aye. Do I have a motion to report and re-refer to Finance? Okay. So open the roll. All in a green vote is vote to report and re-refer. Okay, next Delegate Hope.
Ayes 14, no zero.
1908. There he is.
Thank you, Mr. Chairman.
This bill is similar to Senate Bill 1507 from Senator Mason that reported from this committee 15-0 and passed the Senate 39-0. And this bill started out identical to you and Senator Mason had the identical bills. Do you mind if we conform? Do you know what the differences are?
I don't know. I think there are some slight differences.
Mr. Chairman, the difference, not to interrupt Delegate Hope, the difference is largely grammatical. I think the Senate had superior editing on this bill.
That'll be a
And
first.
That's the difference.
Do I have a motion to conform the bill to 1507? Okay,
First time for everything, you know?
all in favor of that motion, say aye. Aye. The bill were passed out of this committee 15-0, the Senate 30-0. Do I have a motion to report the substitute?
So move.
Open the roll. All green vote is a vote to report. Thank you, Senator Hope. Delegate Hope, that was a
I got
wonderful
another-
presentation.
Ayes 15-0.
Mr. Chairman, I have another House Bill 2323,
2323, okay.
or a posting of legal notices at the courthouse.
That's on it's on the last page of your agenda, page 10.
Mr. Chairman, members of the committee, this just says that notice is required by the Virginia Code. We posted at the courthouse in a location designated by the chief judge of the circuit and on the website of the circuit court clerk or the locality in which the court was located. This has a delayed enactment because that was a request of the circuit court clerks to give our rural populations a chance to update their websites so that they can have these notices posted in both places.
Okay, I think this is pretty much the practice in a lot of the courts where I work, but does anybody have any questions for Delegate Hope? Is there anybody in the audience who wishes to speak in favor or against this bill? The bill passed the House 98-0. That doesn't mean anything, but we might want to report the bill. Okay, there's a motion and a second. Are there other motions? Please open the roll. Vote yea is a vote to report. Okay, thank you.
Thank you, Mr. Chairman.
Ayes 15-0.
Okay, the next I've got is Delegate Ballard. 1385.
Thank you, Mr. Chairman.
And this is a bill that passed the House 98-0. That doesn't mean anything. But
Also means nothing, Mr. Chairman, I understand. I mean, it's just strictly an administrative cleanup bill, pretty straightforward. So when parties obtain a divorce, you can present evidence that they satisfy the divorce requirements by affidavit. The statute that governed that, 20-106, conflicted with 20-91, which was the statute governing the grounds for divorce. So all this does is it matches those two up so it reads the same.
Move to report.
was there anybody here that needed to speak to this bill? Been a motion to report and a second. There are no other motions. Open the roll. Is that your only bill, Delegate?
One more,
Ayes
Mr. Chairman.
15-0.
1440, Mr. Chairman.
1440. Okay.
Also, pretty straightforward bill, Mr. Chairman, members of the committee. It's amending code 8.01-418 relating to a finding of guilt in absentia. Essentially, what we're wanting to do with this bill is it treats a failure to appear and resulting in a finding of guilt in absentia the same as prepaying the ticket. So a finding of guilt that can then be used as evidence in a related civil action.
Servo.
Senator Servo.
This is way overdue, and I'm glad he put it on. Can't believe I didn't think of it myself.
I'll give you partial credit, Senator.
Well, I want to understand.
Yeah, well, thanks for that. Guy comes up.
Did you want to speak in favor of the bill or against it?
Mr. Chairman, Mr. Chairman.
Senator Peake.
And I will say, I'm going to put one red on here. Sometimes they might be out of town, they might not know, something happened, and they don't show. So
Yeah.
I'm going to post that there ought to be something kind of correction. I'll get with you and see, but it might not matter. You're going to get out of here.
Mr. Chairman, a
40,
question
30
I have.
Senator Edwards has a question.
If the criminal court records are silent or ambiguous, you got to have some record, though, as to what happened, don't you?
What's going to show you when they're found guilty?
Yeah.
And he still can come and say, I was out of town.
Yes, just evidence.
So right now, if I go to court and plead guilty, that's admissible. And you're treating a finding and abstention the same way.
You have to have a record, though.
Again, it's not dispositive of the issue, it's just the evidence. And certainly you can show up and contest that evidence, and then the court would make a finding, Mr. Chairman.
I got you. Yes, sir.
Afternoon, Mr. Chairman. Mark Dix on behalf of the Virginia Trial Lawyers Association. We support the bill, and we appreciate Delegate Ballard bringing it forward. Thank you.
Well, let me be clear, because
Senator Edwards still has
are you
questions.
saying there is a document, though, that says the guy didn't show up or something, some official document, and was found guilty?
Mr. Chairman, Senator Edwards, it would be on the summons, as the senator said, and so that would be the document I think that you're referring to.
All right.
And then again, that's just the evidence in the related civil matter. It's not dispositive of the issue of guilt or liability. You can still show up and contest that.
Are there additional questions? Are there additional people that want to speak to the bill? Is there a motion on the bill? Motion made and seconded. Are there other motions? Please open the roll. Vote yea is a vote to report.
Why are you voting against it?
Senator Obenshain? Ayes 13, noes 2.
Ayes 13, noes 2. Your bill's reported. Thank you very much. The next was
Thank you, Mr. Chairman, members.
Delegate Taylor, 1404. I apologize when you were up here the first time. Come on. This bill did not have a Senate cognate. 1404.
Good afternoon, Mr. Chair and members of the subcommittee. Today I'm here to present HB 1404, which seeks to add the definition of heated tobacco cigarettes into the Cigarette Delivery Sales Requirements Act. The addition of this definition will correct one of two definitions of cigarettes in the Virginia Tax Code. It will also protect minors from the illegal home delivery of heated tobacco cigarettes. This bill corrects an unintended consequence of the 2019 Senate Bill 1371, which for tax purposes, heated tobacco products were no longer classified as cigarettes. This bill redefines cigarette to exclude the term heated. Heated tobacco was reclassified as a tobacco product under the Virginia Tax Code. Tobacco products are products such as pipe tobacco, snuff, and chewing tobacco. It is necessary to add a specific cigarette definition to the Cigarette Delivery Sales Requirement Act to ensure that heated tobacco cigarettes continue to fall within the regulatory requirements for the Code of Virginia.
Are there other questions for the delegate?
Mr. Chair.
Senator Peterson.
You keep using the phrase heated tobacco. I'm looking at line 18 of the bill, and the only new language to me is just said cigarette means the same as that term is defined in 3.2-4200.
I think you need to look at that section.
Well, I guess so, but I don't have it in front of me. What,
That's my question. What does that say?
what does that say?
So, Mr. Chairman, the definition of cigarette under section 3.2-4200, cigarette means any product that contains nicotine is intended to be burned or heated under ordinary conditions of use and consists of or contains, and then it lists any roll of tobacco wrapped in paper or any substance not containing tobacco. Romanet 2, tobacco in any form that is functional in the product, which, because of its appearance, the type of tobacco used in the filler or its packaging or label, and it goes on. But I think obviously the important part of this is cigarette means any product that contains nicotine is intended to be burned or heated under ordinary conditions of use.
Okay, follow-up question.
Senator Peterson.
So pipe tobacco, and I'm the son of a pipe tobacco smoker, or was, that maybe a corollary there, but what is that included in now as a quote cigarette under this law? Is that what you're saying?
No, it was the heated tobacco. For tax purposes, it was changed in 2019, and that allowed for online sales. So we don't want underage or minors purchasing these heated cigarette products online. It's different than a cigarette. It has a chemical reaction versus actual lighting.
Further question, Mr. Chair.
Senator Peterson.
So are you now talking about one of those vaping things, or?
No, it is not vaping. Unfortunately, I really would like to have seen one of these, but.
Anyone in the audience have one, maybe? You got, no, okay. Yeah, of course you're over 18, but all right. All right. Okay.
Are there any serious questions? Are there people in the audience or those who would like to speak in favor of this bill? We got somebody who wants to speak in favor of the bill.
I rise solely in the interest that, believing as a young man, I have seen
What's your name, please?
My name is Jackson Pretis.
Where are you from?
I'm a cadet of Fort Union Military Academy.
Okay.
I'm the chaplain there. I've seen the tobacco crisis firsthand as a young man. I've seen the nicotine crisis firsthand, and I've seen how it has reduced young men and young women to shells of themselves. And so I believe that this bill and defining and including the definition of nicotine there is vital as a step towards remedying that crisis and seeing an actual action towards benefiting a youth that is currently, on the precipice of an even further crisis. Because in my opinion, there's not enough being done to combat nicotine use and tobacco use. And so I highly welcome this definition.
Okay, thank you, sir.
You're very welcome.
I wonder if he has a cigarette. We might ask him.
Mr.
Other people
Chair.
would like to speak in opposition to the bill. Senator Peake,
Well, if no one's in opposition, I'll go ahead and speak to it.
okay.
No one else. I'll just point out that young man and all those guys back there are from Fork Union Military Academy, right in the heart of the 22nd Senate District, and I move to report this bill.
Is there a second? Okay, are there other motions? Please open the roll. A vote yea is a vote to report. Okay, Delegate Herring.
Ayes 15, no zero.
Thank you.
Herring. 1990, is that right?
All right, yes. Good afternoon, Mr. Chair and members of the committee. HB 1990 comes from family law attorneys who have asked I put it in to bring more clarification to the code. Guardian ad litems are appointed, and we know that they should represent the child, parent, guardian, or any other adult at all stages of the proceeding. This bill clarifies that means including appeals to the circuit court. Language was also included in the substitute that you're looking at, and we added unless relieved on replacement in the manner provided by law. Some family law attorneys, expressed concern that they only practice in the JD&R court, so that was additionally added in. And so.
I'm just wondering, Delegate Herring, this
Yes.
language, any attorney appointed to represent the child or parent, guardian, or other adult pursuant to this section, are we just talking about guardian ad litems or court-appointed counsel? Because the appointment of counsel is also something that's addressed on line 11.
That is true, so it applied to both?
It applied to
Looking
both.
at it, yes. And we do have permissive as they may.
Are there additional questions for Delegate Herring?
Mr. Chairman,
Senator Surville.
thank you. Is Family Law Coalition here? 'Cause I don't see, 'cause, JALs are widely used in my jurisdictions, or at least in juvenile courts, but we don't see them in circuit courts a lot. And, circuit court and appeal is a whole different ballgame often in terms of the level of effort acquired, and which means, the bill gets run up and eventually the court has to allocate cost between parties. And, usually they're used more in juvenile court because there's a lot more pro se parties as opposed to circuit or on appeal. And so I was wondering if the family law bar looked at this and where they came out.
Mr. Chairman, Mark Dix on behalf of the Virginia Family Law Coalition. This is not our bill, but we looked at this issue, and the experience of our practitioners is that there's inconsistency amongst the circuit courts as whether they allow the same GAL to continue. Sometimes things do not go well with the GAL and JDR, and they'd like to change it up in the circuit court. So we tried to make it that once you're appointed in the JDR court, you have to see it through, but on appeal, the court is empowered to change it up.
Well,
Okay.
Mr. Dix, I would ask you, doesn't the language on line 15 may assure that there will continue to be some inconsistency?
So, Mr. Chairman, my understanding is that beginning on line 12, it's saying if you're appointed, that you will continue to represent them. But then on 14, you may continue to represent them upon the appeal to the circuit court. That was how we interpreted the language, is that in the JDR court, you're in it until you're relieved. On appeal, you may continue until you're relieved.
Okay, are there additional questions? Are there others in the audience who want to speak to this bill? Okay, the committee operates by motion.
Second.
Okay, are there other motions? Please open the roll. A vote yea is a vote to report. Okay, Delegate.
Ayes 15, no zero.
1991.
Yes, sorry, Mr. Chair. I was just a little nervous there, sorry. 1991 is dealing with the 21-day rule on divestiture from the JDR court to the circuit court. On appeals, there were courts in the Commonwealth that handle it differently. Some interpret it that you are to at least docket the case for a hearing that must occur within 21 days, or actually whether the hearing must occur in 21 days. So this bill provides sort of a fix, of the best that we could think of, to make sure that it's clear what's supposed to happen in 21 days. Some dockets are heavier than others, so that there won't be sort of additional litigation about whether a matter was heard within 21 days for divestiture.
Senator Servo.
This one cleans up an ambiguity in the law, which has been a real headache. I mean, normally because of this, you have to set a hearing within 21 days, but sometimes the courts don't allow hearings of a certain length to happen within that time frame, and it creates confusion about whether or not it was actually removed or not or whatever. And anyways, this will provide some clarity and certainty in these situations. I think it's a good idea.
Are there those in the room who would like to speak to this bill? Are there other questions from the committee? If not, we operate by motion.
Second.
Okay, a motion to report and a second. Are there other motions? Please open the roll. A green vote is a vote to report. Okay, thank you, Delegate.
Ayes 15,
Hayes.
no
Thank
zero.
you. Appreciate it.
Okay, Delegate Hayes, you have one bill, is that right?
That's correct, Mr. Chair. HB 2221.
Okay, HB 2220, it's on the last page of the docket. 2221.
21.
Yes, sir. 2221. Delegate Hayes, please give your attention to him.
Thank you, Mr. Chairman. Members of the committee, you have before you House Bill 2221. Currently, the code allows for certain circumstances where an hearing is required that two-way video, audio communication is allowed. This measure just simply adds to that list when there's a waiver of hearing, your preliminary hearing, and all parties agree. It simply says that you may use this technology for that purpose, and it's just adding to the list of other circumstances in which it's allowed.
And everybody's got to consent, with the consent of the court and all the parties.
Yes, sir.
Any questions from the committee? Anybody in the room who feels compelled to speak to this bill? Okay, there's been a motion to report and a second. Are there other motions? Please open the roll. Okay,
Ayes 15, no zero.
thank you, Delegate.
Thank you, Mr. Chairman.
Delegate Adams, you have two bills. Is that right?
Yes, sir, Mr. Chairman.
2012 and 2017. They both barely eked out of the House of Delegates. 98 to nothing.
Right. Well, thank you, Mr. Chairman. And dealing with the first House Bill 2012, this came as a suggestion by, I think it was Legislative Services, were receiving information that there are some appellate judges who had noticed that in 2018, when the code sections involving recall judges and the General Assembly's ability to review judges that are on recall. When that happened, I believe that the appellate judges were inadvertently removed or omitted from the judges who are able to come in and sit in recall in circuit court. And so, so the suggestion was made to just amend Code Section 17.1-106 on line 16 to allow not just judges who are retired, but any justice of the Supreme Court or judge of the Court of Appeals under the judicial retirement system to sit.
Do you understand the bill? Are there questions from the
I've got
committee?
a question.
Yeah,
Delegate Senator Obenshain's got a question.
Les, these Supreme Court justices, I mean, are they just being called to sit on Supreme Court cases? Or are you telling me that they're being called to sit in circuit court?
This would allow them to be called to sit as a trial judge. I understand that that was the allowance before, probably not used that often. Seems to have been, that ability was removed, but not with debate.
Further question.
Senator Obenshain.
Would this bill allow the Supreme Court to recall to sit on panels retired Supreme Court justices who are not senior justices? Does that make sense?
No. Mr.
So
Chairman,
when you retire from the Supreme Court, you either retire or are a senior justice. And my understanding right now is that only senior justices can sit, and I'm kind of looking at the Supreme Court back there, can sit on cases. Is this intended to, or does it open up the universe of Supreme Court justices who can sit on panels or decide cases in the Supreme Court?
Mr. Chairman, my understanding was that this was dealing with trial courts.
Mr. Chairman.
Senator Peterson, I think, had
Servo.
something. Senator
Well,
Servo
I'll
had
defer to
something,
Servo.
and Senator Morsi has something.
First of all, I think the intent is retired if you look at the title of the statute, but if you read the words of the statute, it doesn't say retired, which is what got, I think, Senator Obenshain, I suspect, got his attention. But I can tell you that I once had a circuit court trial with, I think, Judge Annunziata.
I had one with Joanna Fitzpatrick.
And, but it seems to me it ought to only be for retired Court of Appeals or Supreme Court justices, not actively sitting judges or justices. And I don't believe the text of the statute says it, even though the title of the statute seems to want to say that.
It does say retired.
You don't think this language on line 17 that says retired under the judicial retirement system applies to?
Oh, I didn't see that part. Yeah,
Justice of the Supreme Court, judge of the Court of Appeals?
You got to be retired.
Yeah, that gets it. Never mind.
That does get it.
Don't listen to me.
Mr. Chair.
Well, Senator Peterson, Senator Morsi's got a question first.
I cut off. Go ahead, Joe.
Delegate, sometimes we can wordsmith things a little too much. Isn't the intent of this bill to free up more judges available for recall and limiting that to these justices of the Supreme Court who are retired of the Court of Appeals? Isn't that the bill in its entirety?
Mr. Chairman, yes, Delegate Morsi, I believe that would be the intent.
Okay, thank you.
Senator Peterson.
Well, I was
Sorry, Senator Morsi, did you have more?
No, I'm finished, Mr. Chair. Sorry.
Senator Peterson.
I was going to say, we have had this wrestling match with retired judges over the last couple of years. Does this mean now that these retired Supreme Court justices and/or Court of Appeals judges will then come back to us for the review that we've talked about for all other retired judges? Because they're not in it right now.
Well,
That's not what it says.
Mr. Chairman, Senator Peterson, I believe if they were on that list of recall, they would be
Then they'd
included
come
in that
back.
list.
Okay.
Right, for review.
Okay, fair enough.
I've got a question for council. The delegate has said this was basically formerly the state of the law. What was that? Is that so? And when was it the state of the law?
Prior to 2018.
Yeah, I got it. Okay. Mr. Chair.
Senator Servo, or Senator
Peterson.
Peterson, I apologize.
Okay. The 3-year look back, it looks like it only applies, and I appreciate Senator Morsi pointing this out, it only applies to circuit court. And so the question is, do we only want to do a 3-year look back for circuit court? And are we saying that Supreme Court justices or judges from the Court of Appeals basically get no review? Because that's what we have right now.
Do you want to apply the 3-year look-back language to the judge, to the appellate
Yeah,
judges?
I would move that.
Move that in concept? Do you have an objection with that?
I have no objection to that.
Okay. But a motion made and seconded to develop language to apply the 3-year look-back to the retired judges of the Court of Appeals or Supreme Court.
Mr. Chairman, yeah, there's a problem there because these are not trial judges to begin with. They were appellate judges to begin with.
Right.
And they were retired. And I don't know, we need to do a 3-year look back in that
Okay.
situation.
That's why we do need to do it. Mr. Chair, if I might.
Senator Peterson.
That's exactly why we need to have a look back. They may never have tried a jury case in their career, and if that's your jury case, that may be a problem. So I do think we need to have some type of scrutiny. I don't, just because we send somebody up to the big bench doesn't mean they're better than the rest of us. Yeah, exactly.
Okay, all in favor of that amendment, that conceptual amendment, say aye. Opposed, say no.
No.
Okay, one no. Okay, we've got that conceptual amendment agreed to. Are there further questions, Senator Morrissey?
If we have that conceptual amendment agreed to, is it proper posture now to make a motion to report?
Let's see if there are people that want to be heard on this issue. Are there people in the audience that would like to be heard? Charles, I apologize.
Mr. Chair, earlier you asked when was the justice taken out? And in the 2018 session, the old 17.1106 said the Chief Justice of the Supreme Court may call upon and authorize any justice, and justice was struck. So prior to 2018, justices were allowed to sit and recall.
Was it Stewart's bill to undo that, take that out?
Yes, Mr. Chair. It was Senate Bill 939, patroned by Senator Stewart.
Well, if we put it back in, but we require a 3-year look back,
That would probably be, the policy that was adopted in 2018 was to require the 3-year look back for circuit court justice, and that's why I believe justices were struck out. But it would be consistent to, if you want to have them sit and recall, to put them
Stewart's not
back in.
here, so we can do it anyway, right? Okay, are there those in the audience who want to be heard on this issue? If not, Senator Morrissey has a motion.
Move to report with the amendment that will be reduced to writing.
Okay, is there a second? Second. Is there an additional motion? If not, please open the roll. A green vote is a vote to report. Okay, you've got another bill.
Mr. Chairman?
You got to vote.
Mr. Chairman?
Apologize.
Ayes 14, no zero, abstentions 1.
You've got 2017.
Yes, sir. Thank you, Mr. Chairman, members of the committee. This bill would add to the list of charges for which a juvenile court is required to conduct a preliminary hearing for juveniles 16 years of age or older, the charge of 18.2-90, which is the entering of a dwelling house with the intent to commit murder, rape, robbery, or arson. This was a request by the Department of Juvenile Justice, Department of Public Safety, I think someone had just noticed in their own personal practice that this particular code section was missing. When you look at the surrounding code sections and offenses, it's all a similar seriousness.
Well, let me ask you, Delegate Adams, does the holding of a preliminary hearing mean that the child is being transferred to be tried as an adult?
Yes, that it would be that case. So
Okay,
this is.
So we are basically expanding the type of expanding the cases that can be transferred.
Yes, Mr. Chairman.
Okay.
And in particular, it's adding it to subsection C of that statute, which, as some of the members I'm sure are aware, is the section by which a prosecutor, on providing notice, is entitled to the preliminary hearing, whereas in some of the other subsection involves the option of a transfer hearing.
Mr. Chair.
Senator Morrissey.
Delegate, earlier in this session, the co-chair of Senate Judiciary, Senator Edwards, gave a lengthy presentation about how juveniles that are under the age of not just 16 but 25, but 15, 16, 17-year-olds' minds are not fully developed. And I actually thought that we would be going the other way. In other words, taking cases off instead of adding to them. And I'm just wondering if you gave any thought to that position, that these juveniles' minds are simply not developed that to such a degree that we warrant trying them as adults in circuit court? Just be given any consideration.
All right, and thank you, Mr. Chairman, Senator Morrissey. Yeah, that has occurred to me as I've raised a teenager, that often long-term consequences are not at the forefront of a juvenile's mind. What I would say about this particular code section is that it's not an expansion in a way that is looking for something that doesn't already fit. In other words, if a juvenile is charged with murder, for instance, that requires no notice, that's covered under subsection B, that's an automatic preliminary hearing. Under subsection C, you have other serious offenses like abduction, malicious wounding, distribution of drugs, forcible sodomy. In this case, it's not all breaking and enterings, just the breaking and entering that is done with the intent to commit murder, rape, robbery, or arson. And so my argument would be that this is not an expansion of something new, or maybe even that wasn't contemplated before, that it fits within the degree of serious charges that the legislature intends. A prosecutor is authorized to have that choice on pursuing.
Mr. Chairman, I have a question.
Senator Edwards.
What's the difference between a transfer hearing on page, line 17 and a preliminary hearing of a juvenile on under C, line 64? What's the difference between a transfer hearing and a preliminary hearing?
So, Mr. Chairman, Senator Edwards, I believe the difference is in the ability of a court to keep it within its jurisdiction, or if it's simply looking at it from a standpoint of probable cause. So I think at a preliminary hearing, the case is proceeding as if the juvenile were an adult. And I'd welcome any correction by counsel if that needs to be expanded upon.
I've never understood the difference. In a transfer hearing, don't you present evidence?
Good afternoon, Mr. Chairman, members of the committee. I'm James Toohey from the Department of Juvenile Justice. Under the transfer hearing, which can apply to any felony, the judge considers multiple factors in deciding whether it's proper for the juvenile to remain within the jurisdiction of the juvenile court. Under subsections B and C, they carved out specific offenses which are of such severity that they should be treated differently. Under subsection B, those are subject to a mandatory preliminary hearing or an automatic preliminary hearing. So they're not something where the prosecutor asks for a transfer hearing and a transfer hearing is held. They automatically go to a preliminary hearing. Under subsection C, those are offenses that are also considered the severe offenses. But what happens under subsection C is that it's the prosecutor that has the discretion to certify it for a preliminary hearing, and then a preliminary hearing happens that way. And so under subsection B and C, that's why in 1996, the General Assembly added those more severe offenses, and we feel like this is an offense that is as severe and more severe in some cases as those that are included, such as adulteration of food products and some of the drug offenses, because it involves the intent to commit murder, a rape, or robbery.
There's a difference in transfer hearing. The judge has discretion whether to transfer to the circuit court or not.
Yes.
Whereas a preliminary hearing, assuming there's probable cause, the case will be transferred.
That's correct. But under subsection A, when the judge has the discretion, that applies for all felonies.
Right.
So subsection B and C, which goes to preliminary hearing, those are for the specified severe offenses.
I see. They will automatically go if there's probable cause.
Yes.
Are there additional questions? Okay, are there people in the audience that would like to speak to this issue? For or against? Okay, the committee operates by motion. Got a motion to report? Is there a second?
Second.
Got a motion to report and a second. Are there other motions? Open the roll. A vote yea is a vote to report.
Ayes 9, no 6.
Ayes 9, no 6. The bill's reported. That was your last bill?
Yes, thank you, Mr. Chairman.
Delegate Sullivan.
Good afternoon, Mr. Chair, members of the committee. 1581, want to start there?
1581.
First thing I would ask, Mr. Chair, is that you not hold against this bill the fact that it passed the House 98-0.
I don't know. Senator Delegate Sullivan. There are a whole lot of bills over there that have 98 votes. There's something going on. I don't know what it is.
Well, this particular bill, Mr. Chair, I got from the Supreme Court, and it's a recommendation of the Judicial Council and the Committee on District Courts.
Uh-oh.
So I'm just trying to beef it up here. And OES is here to talk about it as well. What it does is it simply streamlines the process for overseeing approving parent education seminar providers. Educational seminars are always required for parties in contested custody or visitation matters, or at least have been since 2000. The Department of Dispute Resolution Services and OES vets and trains and makes recommendations to the courts for approval of these providers. And no court's ever rejected one of those recommendations. All this bill does is take that burden off the court and says what the Office of the Executive Secretary will have the authority to approve these new seminar providers and recommending them to the local courts.
Okay, does everybody understand the bill? Are there any questions? Is there anyone in the audience who's compelled to speak to this bill? Okay, Senator Peake has a motion to report. Is there a second? Are there other motions? Please open the roll. A vote yea is a vote to report.
Ayes 15, no 0.
Ayes 15, no 0. You've got another bill, Senator Delegate Sullivan.
Thank you, Mr. Chair. 1583, Mr. Chair.
1583.
Thank you, Mr. Chair and ladies and gentlemen of the committee. This bill has to do with the code, one of the code sections having to do with the crime of peeping, which is, I guess, still a thing. 18.2130 deals with old-fashioned peeping, walking up to a door, looking up to a window and looking inside. 130.1 is, I guess, sort of newfangled peeping. It deals with electronic devices and using them to peep into a building. You'll see all this does is, I think, create a fix, actually. First sentence makes it unlawful for a person to knowingly and intentionally cause an electronic device to enter the property of another. Later on, you'll see, and I'm not changing anything there, deals with devices that are left in a property. I think camera or something. That deals with a landlord who might install a camera and look and use it to peep. The question becomes, how does a device intentionally enter the property of another? And this really deals with drones. And so the question becomes, it can't be peeping, or it shouldn't be peeping if the drone is over someone's backyard.
That's what this bill's about, drones.
Yes, sir.
I was trying to figure out where.
How do you get an electronic device into a home?
We thought of spy balloons.
Exactly, or a spy balloon.
Is there somebody behind this bill, or just?
This came to me from the Commonwealth's attorney, yes, sir.
Commonwealth's attorney.
So the point, what this does is, as written, a drone could be over the person's backyard and they're peeping because you're on the property of another. But it could be over the neighbor's yard or out in the street, and it would not fit within this code because it hadn't entered the property of another.
Mr. Chairman?
Senator McDougal.
So if you had a telephoto camera and you were outside, but you were not on the person's property, and you took a picture and they were in their backyard, then you could be in violation of this statute, because you would be in an enclosure, like say they have a lean-to on their backyard or a back porch.
Mr. Chair, Mr. Chair and Senator McDougal, the reason there actually is another code section which had originally been a part of this bill, 18.2-130, which deals with that issue of what if you're across the street looking through a telescopic lens or something like that. But the committee, on my side, in its wisdom, took that part out of the bill, and this just deals with 130.1, an electronic device, which, as I understand it, when this bill was passed some time ago, was a reference to drones.
Senator Edwards.
This is a Fourth Amendment issue. Haven't looked at it that carefully, but they put something on the wall of a house to get information inside the house, the Supreme Court has held that's a violation of the Fourth Amendment. Because they're inside the house, but
Like a posters?
device is on a wall outside the house, but they can listen inside the house, is what's going on inside the house. That's a Fourth Amendment issue. It's a violation of the Fourth Amendment, according to the U.S. Supreme Court, Justice Scalia's opinion about 20 years ago. Have you looked into that?
Mr. Chair, Senator Edwards, candidly, I haven't. That sounds like a criminal law issue having to do with law enforcement surveilling a suspect. This is simply the section of code that deals with someone knowingly and intentionally trying to peep into someone's house using a drone.
Mr. Chairman?
With a drone with a mounted camera on it.
Mr. Chairman, I guess I'm very good if that's what it does. My question is electronic device, and I hate to agree with Senator Edwards a little bit, but what if you had law enforcement that had a video camera set up across the street, or your Ring doorbell across the street, and it's catching the visual through the window or through the door? Is that not an electronic device? I mean, I don't like Ring doorbells, but they're everywhere.
Yeah. Mr. Chairman, Senator McDougal, with all due respect, I don't think this would have no effect on law enforcement's ability to surveil or build a case against someone. This has to do, there's lots of requirements here, secretly and furtively peep or spy intended for occupancies of dwelling to peep or spy through a window.
But if a law enforcement doesn't want the person who's being investigated to know they're there, they're furtively acting.
Mr. Chairman, the language on line 18 excludes law enforcement.
Okay.
Mr. Chairman.
There it is.
Where's that?
Thank you.
The last sentence, the provision.
I knew it was there somewhere.
Yeah.
Thank you, Mr. Benjamin.
Senator Servel's got some. Well, Senator McClellan was before Senator Servel.
Yeah, so this would also apply, let's say you've got a private investigator who's trying to get evidence that someone is cheating on their spouse, and they set up across the street from the house to take pictures. That would be captured, even if they have permission of the person across the street from the house, that would now be captured by this legislation, right?
I think the answer to that is, Mr. Chair, Madam Senator, I think the answer to that is yes.
Follow-up question, Mr. Chair.
Senator McClellan.
And you remember the movie Rear Window? Let's say you've got someone who's sitting in their window taking pictures from their window, and they happen to get a picture of someone standing in the window across the street. That would be captured by this legislation as well, right?
Mr. Chair, Senator McClellan, I think the answer to that question might be no, because a camera is not an electronic device, as I understand how it's been.
Most cameras now are digital.
Fair enough.
Most cameras are cell phones or iPads.
Most cameras.
For that, Mr. Chair, Senator McClellan, for that I would direct you to 18.2-130, which makes it still a unlawful for a person to secretly or furtively peep, spy into or through a window. That's already against the law.
Mr. Chairman?
Senator McDougal.
If we change the electronic device to drone, or the language that we would use for drone, would that fix your problem and maybe solve some of our concerns?
It might solve some of those. I would have no objection to that, Senator.
What do you think of that?
How do you do this?
What's wrong with Mr. Chair, what's wrong with electronic device?
Well, you've heard some of the
Well,
issues
if somebody,
that were raised.
Mr. Chairman,
Senator Peake.
So is it less offensive if somebody uses a phone or a telescope or a super high-powered camera to spy through my window and take pictures of my wife getting in the shower than if they send a drone overhead to do it?
But Senator Peake, if you have a divorce case and your client pays you to hire a detective to find out what's going on with their spouse, and you've got your detective across the street with an electronic device taking pictures of people coming in and out of that
This says
apartment.
without just cause.
Well, you're violating the law though under that.
Well,
So if
so
the
then
problem
that-
is drones, maybe if we just limit it to drones.
What if Mr. Chair? Mr.
Senator
Chair,
Peake.
what if the private detective is using a drone to see if anybody's coming in and out of your back door? Then that's illegal too.
Well, that's illegal too.
So that means private detective can't use cameras or a drone.
Okay,
Chairman.
let this bill go by for the week and we'll try to figure it out.
I've been speaking with counsel.
Yeah.
We'll try to address people's concerns.
Is that, we'll try to figure that out. Is Delegate Wilt
Mr. Chair.
here? Delegate Wilt, you just came in. Well, why is your,
Mr. Chairman, I'm going to go get a lottery ticket as soon as we're done here.
okay,
Well, we're not done yet, so
okay. I know there have been people waiting longer, but his name was the first one on the list. It's 1459, right?
sorry.
1459?
Yeah, that's correct, Mr. Chairman. Yeah, and it really is a simple bill. What it does, it allows all state law enforcement officers upon retirement to request to retain their badge, provided it's mounted. And that would be like on a board of some sort that they couldn't carry around their pocket and use in the wrong manner. That's already allowed for the Virginia State Police, and it expands it to all state agencies. And, Mr. Chairman, I believe that other laws, like the sheriff's departments, and they can already do this. So that's the
Okay,
bill.
does anybody have any questions? Everybody understand the
Yeah,
bill?
yeah,
Are there those in the audience who would like to speak to this bill, yay or nay? Do I have a motion?
I do have a question, though.
Delegate, Senator Edwards has a question.
You're not talking about private security guards. You
No.
got to be an official of state or local official law enforcement officer. Is that
Yeah,
right?
Mr. Chairman, I would answer the senator that, no, this is only state agency law enforcement, not even the sheriff's, but they already have that ability.
It's like an ABC officer or
Yeah.
a DMV officer or something. This language
Correct.
is
Okay.
consistent with the code section that allows retiring state police officers to get their mounted badges on retirement. Is there a motion on the bill?
So moved.
Okay, is there a second? Okay, moved and seconded, the bill be reported. Are there other motions? Please open the roll. A vote yea is a vote to report. Thank you, Delegate Wilt.
Thank you, Mr. Chairman, committee members.
Delegate Bourne, you're next.
Ayes 15, no zero.
All right. I think this is another one of those 98 to nothing.
I'm suspicious about that. Something going on over there. Something in the water.
Well, I mean, all the good bills, they got 48 votes in the House. The ones that were actually heard. Anyway, Mr. Chair, members of the committee, this is a simple bill that clarifies what fees mean in 801-267.1, which governs the way that courts can organize and manage combined litigation, and specifically when they're allocating costs and fees. Fees has always, I think, colloquially been understood to mean attorney's fees. However, lately, some attorneys have injected some confusion. Following the conclusion of a case, they've argued that fees in this code section refer to expert fees or filing fees, not attorney's fees, and thus the matter, and then argued how those fees should be distributed remains a question. And this bill simply seeks to remove that doubt or confusion by specifically saying that these fees, as contemplated in the code section, refer to attorney's fees.
Does everybody understand the bill? Are there any questions?
Yeah,
Senator Edwards has questions.
There's, in our area, when it comes to expert witness fees, the judges on their own came up with a methodology for them that you basically can't get expert witness fees. Some places I think you can, but this just applies to attorney fees?
Yes, this is just applying attorney's fees and clarifying that those are the fees we're talking about when we're in the code section that deals with civil actions involving multiple claimants, and when they're consolidated, this allows the court to better organize and manage the combined litigation.
Okay, are those in the audience who are compelled to speak to this issue?
Good afternoon, Mr. Chairman. Mark Dix on behalf of the Virginia Trial Lawyers Association. We support the bill and we appreciate Delegate Bourne carrying it.
Okay, are there others? The committee operates by motion.
Move report.
Motion to report. Are there other motions? If not, open the roll. A green vote is a vote to report.
Ayes 15, no zero.
Was that it?
That's it, Mr. Chair.
Okay, thank you, sir.
Thank you so much for your time and attention.
Okay, Delegate Williams-Graves. I've got Delegate Bell first on the list, but I told him that he could go, and he's got one bill, it's simple, we'll take care of it, and we get rid of everybody else. Senator Delegate Williams-Graves.
Good afternoon, Mr. Chair. I am here before you for House Bill 2343.
2343, it's the last bill on the docket. Last bill on the docket. We're going to take care of the bills we've got left on this. I apologize. No, I'm sorry.
It's okay. Thank you. Thank you, Mr. Chair. House Bill 2343 simply looks to remove medical debt in the list of necessities where a hospital can sue a spouse if they're can sue a surviving spouse if the spouse passes away or when the spouse passes away from medical debt in the event that their estate does not cover the cost. Most people have life insurance for the comfort of their loved ones, and some folks don't have an estate that will cover medical debt. And if you leave life insurance for your family members, it is to make sure that they are able to maintain a certain lifestyle or at least be fairly comfortable after you pass. That should not be encroached by hospital debt.
Good bill. You're right, it's a good bill.
Thank you, sir.
Second.
Does everybody understand the bill? There's no doctrine of necessaries with respect to medical bills. Are there those in the audience who want to be heard on this issue? Are the doctors of America screaming with outrage?
Hospitals.
They didn't scream on the House side.
Sometimes they wait to ambush you down the road. Okay, the committee operates by motion.
My property settlement agreement form.
Motion to report and a second. Are there other motions? If not, please open the roll. A green vote is a vote to report.
Ayes 15, no zero.
Okay, thank you, ma'am.
Thank you,
Is
Mr.
that
Chair
all you
and
had?
members of the committee. That's it.
Okay, Delegate Jenkins is next on the list. Delegate Jenkins, we called you early on and you weren't here. We could have gotten rid of you a long time ago, man. Where you been, man?
Probably still in committee, but thank you, Mr. Chairman. Thank you. Mr. Chairman, members of the committee, House Bill 1836 seeks to, I think there's a amendment.
Well, and that's what we were waiting on. We didn't have the amendment. We were told you had it.
Your clerk has
You have it now?
Yeah, Mr. Chair, I can report the amendment.
Okay.
On line 31, after shall, strike convene a stakeholder, insert comma through an existing. Line 31, after group, insert conduct a. And line 31, after study, insert for a period of 1 year from the enactment of this act. So the whole sentence will read, that the Virginia Housing Commission, through an existing work group, shall study for a period of 1 year from the enactment of this act.
Okay, this bill was identical to Senate Bill 1089 from Senator Evans. Do those bills make it conforming to Senator Evans' bill, or it passed this committee 9-6 and passed out of the Senate 22-16?
Mr. Chair, no, this would be different than SB 1089 as it reported out of the
It
committee.
would make it the same?
It
will. Okay, what you're saying is the amendments will be made in the House to make the bills identical. Okay, explain again to me what the amendments do to the bill, please.
Mr. Chairman, what the amendment does is limit this action to 1 year and does not require a special group to convene. That way, getting rid of all the fisc.
You're getting rid of the expenses?
Yes, sir.
Okay.
Does
Does everybody understand the amendment?
Mr. Chairman?
Senator Peake?
I do, Mr. Chair, and I think I was one of the no votes on the companion bill because I didn't like the thought that it was going to cause the state to incur the expenses. And so now with these changes being explained.
Okay, well,
I think I was about to be no.
we have a motion and a second to adopt the amendments. All in favor, say aye. Aye. Okay, the amended bill, are there those in the audience who would like to be heard on this issue?
Mr. Chairman, I do have one question.
Senator McDougal's got a
Maybe
question.
this is for Charles. Is the language on 28 and 20, or 29 and 30, do we have the same time limitations that this was between, I guess, a 1-year period of collection, so this wouldn't be ongoing? I just don't remember what the enactment clause said on the Senate bill.
So, Mr. Chair, to answer Senator McDougal's question, if I'm understanding it correctly, the dates that are included on lines 29 and 30 of HB 1836 are currently the same as SB 1089, if that answers the question.
So, Mr. Chairman.
Senator McDougal.
So both bills, as they left the Senate and as they were before us, had the limitation to 1 year that this data will be collected, not ongoing.
Mr. Chair, to answer Senator McDougal's question, so in enactment clause number 3, beginning on line 31, as the bills reported out of their respective houses or past their respective houses, there was no time limitation on the work group study to collect that data. So this amendment would be putting a time limit of 1 year from the enactment of the bill.
Okay, yes, sir. There's a man behind you, Delegate.
Good afternoon, Mr. Chairman, members of the committee. Tommy Herbert with the Virginia Apartment Management Association, as well on behalf of our sister organization, the Apartment and Office Building Association of Metropolitan Washington. We support the bill, support the amendment, and we appreciate the patron.
Okay, and this is a Housing Commission bill, right?
That's correct. Yes, sir.
No, it's not?
It's the apartment, Virginia Apartment Management Bill.
Okay.
And Apartment and Office Building Association.
Okay. Move to report. Is there a second?
Second.
Okay, motion to report and a second. Are there other motions? Please open the roll. A vote yea is a vote to report.
Ayes 15, no zero.
Thank you, Mr. Chairman.
Okay, Delegate Glass.
Thank you, Mr. Chair, members of the committee, here to present House Bill 2032.
2032. That's on page 9 of your docket. House Bill 2032. Delegate Glass.
All right, thank you, Mr. Chair. So the genesis of the bill is it's an unfortunate situation where many victims of a crime find themselves when their cooperation with the police puts their life in danger. So this bill affects the individuals who are seeking compensation from the criminal injuries compensation fund, also known as the Virginia Victims Fund, who are unable to cooperate with police due to the unavailability of victim or witness protection services. So under the current law, the commission can deny, reduce, or withdraw any reward for a claimant or recipient that has not fully cooperated with a law enforcement agency. So all this bill does is create an exception to that availability in the circumstances where a victim in good faith believes that their life is in danger and would be eligible for protective services, but the law enforcement has requested services, but they cannot provide them. So if you look at line 24 and 25, just to be sure, so you know it's it is requested by a law enforcement agency. That leaves this up to the law enforcement agency to say, yes, this victim's life has a credible threat to their life. They are willing to cooperate, but they are unable to because their life is in danger. And they would still have the opportunity to be eligible for those victim compensation fund.
Okay, Delegate Glass, the governor's made some proposals with respect to the Crime Victims Fund. Has this got any connection to his proposals?
It does not, Mr. Chairman, and this doesn't affect anything budgetary or anything. It will open up the availability for, it means we won't be.
Finance Committee said they want it, so.
Yeah, we would just don't want to be punishing victims because we don't have necessarily the things in place, and there is a budget amendment for witness protection.
Senator Servel's got questions.
Mr. Chairman, I just want to know if Delegate Glass is going to cover me as aggressively in the basketball game on Monday night, because if she does, I'm not sure how favorably disposed I'm going to be towards this bill.
Mr. Chairman, I would answer absolutely.
Oh, shit.
And move to PBI.
You can't bow her out off. Okay.
Second.
She makes fun of me,
Do we understand the bill? Yeah. Are there additional questions? Are there people in the audience who would like to be heard on this issue? Either way. Okay, the bill's before, a motion to report and re-refer to finance. Okay, a second. Motion been made and seconded. Are there other motions? If not, open the roll. A vote yea is a vote to report and re-refer to finance.
Ayes 15, no zero.
Ayes 15, no zero. The bill's reported.
Gratitude, Mr. Chair.
Thank you. Okay, the next name on my list is Delegate Wiley. If not, Delegate Lopez. At long last.
Sure there's someone else you can't take first?
Well, you know, I've got one more name on my list.
There you go. Hey, I have the amendment here that I wanted to just make sure that we address that and move the substantive amendment.
This is House Bill 2071, right?
Yes, sir.
Okay.
And then there's just one issue with the amendment. Everything's fine except the cleanup, I think amendment on line 23 was incorrect. It should say after Lieutenant Governor Virginia, strike and insert or, as opposed to after Governor Virginia. So what this bill does is, or what this amendment does, after working with the Clerks Association of Virginia, it makes this an option, not a may, not a shall. Basically, this bill is about removing unnecessary red tape and making the marriage license process for court clerks much more efficient, less costly, and quicker for everyone involved. Current law in Virginia requires that people that want a one-time authorization to perform a marriage must wait for a judge's signature before they can do it. They also have to give the clerk of the court a $500 bond to hold as a promise that they will return the marriage license paperwork. These requirements, we believe, in conversations with the clerks up in my neck of the woods, think it costs the court system time and money. This bill would fix this unnecessary red tape by giving localities the option of removing the bond requirement and authorizing the court clerks to sign these requests instead of the judges. Due to the bond requirement, clerks have to process checks, hold money, and issue refunds, all of which take time and resources away from the projects that are more important in their office. And then the judge's signature actually hinders our court's ability to do their work in a timely fashion. Additionally, their signature also serves as an unnecessary barrier for state clerks as they...
Senator Peterson.
Yes, I do. And I really didn't pay much attention to marriages after 1996, but now I got to deal with one again.
Okay.
It seems to me the point of the bond, not mine, by the way.
Right.
The point of the bond is they take the license out, but they bring it back. Because everyone's worst nightmare is someone gets the license, they fill it out, the marriage happens, but then they don't bring it back, and so they're never legally married. I mean, that's the nightmare scenario.
So you know,
to bring them back.
Yeah, I completely agree. But it's in the married couple's best interest for the bond to be returned, and so it should be enough of incentive already to guarantee that it's returned.
Right. Further question. I guess my question is the officiant who's posting the bond, correct?
Right. So the issue then, that's why after talking to the Clerks Association, we made this an option. And the biggest thing right now in the bill from our perspective is that you want to have the clerks be able to do this and to sign off on the authorization as opposed to the clerks.
Okay.
I mean, as opposed to the judges.
Final further question, Mr. Chair?
Senator Peterson.
$500 is kind of an odd number, but it's just enough money where you're not going to walk away from it. And again, this is for the officiant, not the couple.
Right.
So the officiant gets the ability to do the license, and he, unlike a pastor of a church, he may not be around. I mean, he
Right.
could be just Uncle Fred.
So
But he wants to go back and get his money.
Yeah, $500. Yeah, I understand that $500 is a lot for an everyday Virginian nowadays, I think, and then also it seems unreasonable that such a quantity should be tied up for a long period of time. Now, I agree with you that it's, just enough for somebody to want to come back and get it.
Right.
Right. So.
Mr. Chair.
First, we have these amendments.
Yes, can we move the
Do we have a
amendments?
motion on the amendments?
So moved.
So moved. Is there a second? Motion and a second to adopt the amendments with the modification that Amendment 4 is after Lieutenant Governor, not after Governor, right?
Yes, that's correct,
Okay.
sir.
All in favor of the amendment, say aye. Aye. Okay, Senator McClellan.
Thank you, Mr. Chair. And I guess, isn't it true that the marriage license, you have a limited window between when the license is granted and when the ceremony must take place, and then it's 5 days after that when the license has to be returned. So I guess you just said you don't want to have $500 tied up for a long time, but it's a pretty finite and relatively short amount of time. I think isn't it 60 days between when the marriage license has to be issued and when the ceremony has to be?
Mr. Chair, that sounds right.
Yeah, so you're basically talking about at most 65 days.
Right, but $500 is for a family making less than $25,000 a
But
year.
they don't pay it.
It has to be cashed. It has to be cashed in some cases. Like the clerk's office has to cash the check and then issue a refund.
No, but the couple is not who pays.
No, I'm talking about the officiant. The officiant might not be making a lot of money. The officiant might be not a person of means, and so they might be doing this because they care deeply about the couple. There's any number of reasons why the officiant might be burdened by $500.
Well, then rather than, Mr. Chair, sorry.
Senator McClellan.
So rather than striking, I mean, I agree with Senator Peterson first, because I sit next to him too long on Finance Committee. But then rather than striking the bond requirement altogether, why wouldn't you just add a provision that it could be waived with, for due cause or?
Well, we tried to fix that with this amendment by saying it may be an option to get rid of the 500 as opposed to.
Okay.
All
Mr. Chair,
Senator McClellan, are you through? Senator Peterson wants round two.
we have
There we
a
go.
contested clerk election in Fairfax, and I'm sure we will all over the Commonwealth, so someone could run like free marriage licenses or something. But this is a serious issue, and I agree with Senator McClellan, and like I said, I'm kind of dealing with these issues. You can get married in front of a circuit court judge anytime you want. I mean, you don't need Uncle Fred to be the officiant. I think you can get married in front of a pastor
Or a state senator.
or a state senator.
Right.
So I guess my point is, and Delegate Lopez, your bill's going to pass. I just think we're just trying to get to the right frame.
Right.
To me, the 500 is actually pretty important because we want that person to come back.
Mm-hmm.
We don't want them to get on a 747 and be like, goodbye.
Mm-hmm.
And I just think that 500 helps bring them back. So I would move that we put the 500 back in and then maybe do what I'll call the McClellan Amendment unless there's some type of waiver that's granted by the clerk for good cause. But I think there's a
suggest
presumption
maybe
that's important.
You do that, and we can work out any problems we've got down the road.
Yeah.
All right. That
I
sounds
make that
good.
motion.
A second, I agree, they ought to have some, basis
Mr.
to
Chair?
come back.
We've got Senator Boysko.
Thank you. Usually when you ask someone to officiate your wedding, it's somebody that you're close to, that you have a personal relationship with.
Right.
The idea that anyone believes that your officiant is going to somehow abscond or forget that they have,
Well, that was my thinking, but.
that seems a little far-fetched to me.
If we've legalized marijuana, they might be smoking.
You never know. I officiated a wedding for two dear friends, and I think my fee was $15 in New York City. And I turned it in immediately. They were dear people, and
In New York City, you had
I
authorization
know,
to do
I
that?
did.
Wow.
So as the proud
I just think
officiant
it's a
of.
little bit,
Right, I agree. As the proud officiant of 4 weddings, I understand this process a little bit, but I am perfectly open to whatever amendments the committee and the chair might have.
Okay, Senator Morrissey's got questions.
No question, just-
I know we do, but you might want to speak to that motion. Are you speaking to that motion?
Thank you, Mr. Chair. I have not officiated any weddings. However, a good friend of mine, Leonidas Young, who many of you know, came to me with a situation with regard to his wife came to a situation. His daughter was married and he was officiant. He passed of cancer, and it was inadvertent that the paperwork was not filed and nobody knew what that paperwork was. I would think that the situation is not so much that an officiant absconds or purposely or with mischief doesn't turn in the paperwork, but just simply errors. So I'm not saying that for any other reason than to perhaps give an explanation why it might not get filed. Senator Peterson.
Thank you.
That's good.
Put $500.
Okay, so Sabrina just pointed out to me that Amendment 2 that I've already adopted puts the $500 back in at
Right.
the discretion of the clerk.
That's what the amendment did. That's what I mentioned too.
You don't think the clerk ought to have discretion? No, I mean, okay, Peterson's made the motion, and somebody else seconded it.
It can be waived with good cause.
That's
what it says.
So he just wants to rewrite the amendment.
I'm waiting here for Senator Benjamin, by the way, so we better vote before he speaks.
Okay. Senator Peterson's got an amendment. It's been seconded. All in favor, say aye.
What's the amendment?
Opposed, no.
What is the
No.
amendment? What is the amendment? I didn't hear it. What is
Well,
the
the
amendment?
amendment is,
The amendment was basically to unstrike the language, would say it may be waived with good cause. In other words, it should be shall.
he liked Amendment 2. He just wanted to word it his own way.
Well, it can be waived with good cause, but it's still a shall. I mean, we still want them to post the bond whenever they can. That's not a meaningless exercise.
While saying though that the clerk, the circuit court clerk can do this as opposed to simply the judge.
I think we adopted your amendment.
That part.
Yeah.
We adopted your amendment in concept. We'll get the wording right. Okay, are there people in the audience who would like to speak to this bill? Okay, the committee operates by
Well,
motion.
Mr. Chair, then I had a
I'm sorry, Senator Peake, I
Yeah.
apologize.
Mr.
Yes,
Chair.
Senator Peake's got questions.
I am just so baffled by this short what are we doing? What is the problem? Why do we need this bill?
So, right now, Senator Peake, the issue is that you have, we're burdening judges with unnecessary administrative tasks and slowing down what the court should be focusing on, which is delivering justice. And so what I would believe is that if we can just allow elected clerks who are already in charge of this entire process to be the ones who sign off on these one-time authorizations for marriage, that should be something we want to do. We also said that we would make it an option.
So that's primarily the thing you're doing. Judges to the clerk.
Mr. Chair,
The second thing.
Mr. Chair.
Senator McClellan.
So at the risk of being told to get my own bill, is anybody from the clerks
They were
here?
Just trying to avoid coming up.
Because if we're trying to take away administrative burden, there's another one. The forms that the officiants have to fill out and bring back, are those mandated in code? Are they created by, like, who creates the form?
Right. Mr. Chairman, Carlos Hopkins, Virginia Association of Circuit Court Clerks, and to Senator McClellan, I'm not sure who creates the forms. Most of the forms in the court are created through the Supreme Court with impact, but with input from others, but I'm not sure who creates the forms for the clerks.
Okay. Here comes the
Okay, is there a
Supreme Court.
motion on the bill?
Well, I might want to answer.
We do not create them. I'm sorry, Brandy Singleton. I'm with Office of the Executive Secretary. We do not create the marriage license form. I believe that's a Department of Vital Records form.
Well, Mr. Chair, so
Senator McClellan.
I'm going to ask the patron to consider, and I don't know if this would be an enactment clause or put it in the code. There is a problem with the form that the people in lines 20 through 24 who don't have to get a court order, the form asks you to fill out the judge and the date of the order, And when one of the people in lines 20 to 24 come to file the form,
They can't fill out that part.
they can't fill out that part, and it leads to a pretty awkward conversation and usually having to go get the circuit court clerk to say, yes, you can accept this. So would you consider a friendly amendment to direct whoever creates these forms to modify the form to fix that?
Yeah.
Okay.
After just conferring very quickly with the folks from the organizations, that would not be a problem.
Might I suggest that we just try to figure that out, and maybe prepare a floor amendment to do that, to add the
I will do
enactment
that.
clause?
Thank you, Mr.
Because
Chair.
the last thing I'd want to do is tell somebody to do it when they're not responsible for it.
I will work with the appropriate people to make sure we direct the
Okay.
appropriate people to
Do I have a
the
motion on the
appropriate-
bill?
Can we see what the amendment says?
No, we're not going to amend the bill. She's going to do it on the floor. Because we don't know who to direct right now. We don't have that information.
Jen, I'll work with you.
Okay, we've got a motion and a second to report the bill. Are there other motions? If not, please open the roll. A green vote is vote to report. Okay,
So-
thank you.
Ayes
Thank you.
12, no zero, abstentions 2.
Thank you, Mr. Chairman, members of the committee. I look forward to working with you on the
Thank you very
amendment.
much. Now, the problem I've got is I've got 2 delegates in the room. I've only got 1 bill left for that, and that delegate's not in the room. Okay, so Delegate Bell has House Bill 1706. It's a pretty simple bill. It's another one that got 98 votes in the House. That no negative votes. It just simply authorizes the National Center for Missing and Exploited Children to obtain criminal history information for the purposes of screening people who are going to work there, or providing volunteer or contractual services. Okay, I have a motion. Are there people in the audience who are compelled to speak to this bill? 2 delegates. You want to stand up and speak for Bill? Okay.
I'll speak for him.
Got a motion to report and a second. All in favor, please vote aye. Vote. Okay, that's the last bills. So
Senator.
we don't have anything from Tato or Price here.
Ayes 14, no zero.
So thank you so much. We're pleased to provide entertainment. You can leave your money at the door. We're adjourned.